Good afternoon. Hello and welcome. You're watching CNN News 18. Hello, I'm Anusha Sonia. Top focus this hour. The fireworks happening at the Supreme Court of India. And this is a constitutional debate that's very keenly watched and is going to be very important for the LGBTQ rights in this country. It's day 2 of the Supreme Court hearing on a batch of petitions seeking legal recognition for same-sex marriage in this country. Yesterday, there were preliminary arguments that pertain to marriage being a way to help assimilate queer individuals in society and to eradicate social stigma. Broad arguments were made yesterday about the contours of the hearing, what should be the broad paradigms. In a big statement, the Chief Justice of India said that there is no absolute concept of a man or a woman based on sheer genitals. The centre has filed a fresh affidavit wanting to state the various state governments to be made party to the hearing. The matter is being heard by a 5-judge constitution bench consisting of Chief Justice of India, Justice D.Y. Chandrachud, Justice Sanjay Kishan Kaul, Justice Ravindra Bhatt, Justice Hima Kohli and Justice P.S. Narasimha. Those are the developments happening. All eyes on that. My colleague Ananya Bhatnagar with us on the broadcast. Ananya, the key takeaways from day 2.
Well, the key takeaways from day 2 would be the centre's affidavit that has been filed before the topmost court of the country, clearly saying that, the states should be heard first. And if at all the states should not be heard and the Supreme Court feels that they do not want to hear all the states, then let the centre complete its consultative process. And remember, this was the demand, in fact, by the Solicitor General of India yesterday as well, saying that, it's a matter of, that connects to very, very deeply to the society and is something that would amount to changes into a lot of things, and that's the reason why, in fact, all of the states' view should be taken into consideration. Apart from that, Mr. Mukul Rohatgi was appearing for the petitioners, has concluded his arguments, and now Menika Guruswamy and Dr. Abhishek Manu Singhvi are actually presenting their views. They too appear for the petitioners in this particular case. Broad argument from the petitioners' end is that they claim an equal right with the heterosexuals, clearly saying that, they all are at the end of the day citizens of India and deserve an equal right to get married and get that marriage actually legally recognized. Various examples were cited by Mr. Mukul Rohatgi while actually presenting the case before the Supreme Court of India.
Let's talk about a key distinction that the bench drew, and this was on day 1. They said about the fact that you have to, the petitioners have to chart or perhaps remain in the territory of the Special Marriage Act, which is a civil/secular law in this country, and the domain of personal laws cannot be touched. This is also something that the central government had highlighted in its affidavit, that there is a broad scheme of personal laws that exist in this country. Marriage essentially as a concept is religion-driven in this nation. And because there are personal laws that exist, it becomes very difficult. That was the argument of the union government. And Justice Sanjay Kishan Kaul also pointed out that perhaps the petitioners should limit their argument to the Special Marriages Act.
Well, definitely, this was a clear distinction, and also, the bench had clearly told the petitioners that, please stay in the limits and of the Special Marriage Act, because if at all, and this was the argument that was also presented by Kapil Sibal, who was actually representing the Jamiyat-e-Ulema Hind, very clearly pointing out that it would have wider ramifications if at all the personal laws are touched when it comes to same-sex marriages, legalizing same-sex marriages, and it would have a wider ramification because all of these personal laws would need to have a change if at all legalization of same-sex marriage has to be done, and that is something that would take a lot of time. In fact, the bench also said that if at all they go into all of these Hindu Marriage Act, or whether we talk of the Islamic laws, that would be something very, very tedious and would require a lot of other views as well.
And in fact, when it comes to personal laws versus individual rights, this is a debate which is still open in many ways. Not just the sphere of the personal laws. There's 6th schedule under Indian Constitution, which is a key impediment to the Uniform Civil Code, according to Law Commission. And we don't have a UCC in this country. That makes it all the more tricky to have marriage as a gender-neutral concept in this country. Let's see what the Apex Court decides. It's a big battle at the Apex Court. Let's talk about another battleground.